Hi everyone, I'm attorney Minhas. I practice U.S. immigration law all over the United States. Today's topic is still going to be about the Parole in Place program, which was announced by President Biden on June 18, 2024. USCIS started accepting applications for parole in place as of Monday, August 19, 2024. So today, after filing a bunch of applications and reading through the Federal Register notice, I've come up with 3 parts of this video. First one is going to be about what's a disqualifying criminal matter. Second topic is going to be about removal orders. And the third one is what happens if your parole in place application is approved? What happens next? So stay tuned. So one of the biggest questions was, what is a disqualifying criminal matter? Before, we didn't have much information, but now that the Federal Register notice is published, we have more information. So if you fall under a category where you feel that you need to really evaluate to see whether you're eligible for a PIP or not, look at the Federal Register notice. Look at what it states and whether the conviction that you have falls under the list of being disqualifying. So typically, if you fall under having a conviction of murder, child abandonment, domestic violence, child abuse, and things like, offenses involving firearms, and there's of course a longer list, then it doesn't matter if it's a felony or not. It's going to be disqualifying. Now, another thing I want to mention is if you fall under the list of other criminal convictions that is not part of that main list, then they will look at factors such as what was your age at the time of the conviction? Were you a juvenile? And, how long ago did that conviction occur? So they are going to look at the sentencing and other factors to see whether the positive outweighs the negative, and then ultimately they're like, all right, you know what, we'll give you the parole in place. So that's what you're aiming for if you don't fall part of that first list. But definitely work with an immigration attorney to see if you qualify for parole in place and whether you can apply. Another thing I want to mention is, great question again, I was contacted about this, is I have a pending criminal charge, or I have a pending charge against me. What happens? Can I apply? So the Federal Register notice has made it apparent that you cannot apply for parole in place if you have open charges, and regardless of what those charges are. However, I do want to say that if the parole in place program is still in effect and you took care of those charges, now you come back and see, okay, do I make the list of the convictions where I'm completely disqualified and I can't apply at all? Or do I make the list of, having positive factors outweighing the negative from the other criminal convictions? So definitely work with an immigration attorney if your charges are taken care of, or if you have charges that are mitigated where they weren't as extreme. Definitely work with an immigration attorney to see whether you qualify for the program and you can apply at that time. So let's talk about the unexecuted final removal orders. So typically, it's a presumption that you're ineligible for parole in place. However, if you have factors that, DHS or USCIS can look at, then they might consider things based on a totality of circumstances. So what does unexecuted final order of removal mean? Meaning you were ordered removed, but you never left the country. And at that time, they'll look at whether you were a victim of fraud because of some type of representation you received, or you had ineffective assistance of counsel, or you were suffering from domestic violence, so you're not able to get to court, or there has to be something that was surrounding that situation. They'll look at the age of when that removal order was given to you. So there's a lot of factors that they will look at. Definitely work with an immigration attorney to see how you can build up on that to fight that presumption and try to see if you can get over, your negative factors by outweighing them with the positive. But of course, you do have to meet the general requirements and also see how you can overcome their decision if it's leaning towards a no, but you can try to get it to a yes. So that's very, very important. I do want to tell you that the Federal Register notice does talk about this, so please do check that out. What happens if your parole in place is granted? So if it's granted, you may be able to apply for a work permit. So you can't concurrently apply for a work permit right now with the parole in place application. However, once you're approved, you may apply for a work permit. What else happens? So you are given a duration of a period on that parole. And right now we know that based on the Federal Register notice, there's no option for them to do, or there's no desire for them to do a re-parole. We can discuss that for another day, but what that typically leads to is that once you get the parole, you now have to show whether you are adjustable for the green card. That's important. So don't all go filing adjustment of statuses because you're like, oh yeah, it's fine. It's an application. Let's just send it out. No, but what if you have pending removal proceedings, right? So if your case is administratively closed and you did that for the purposes of filing a I-601A waiver, what happens now? Those removal proceedings don't automatically go away, right? So you have to discuss this with your attorney, or if you don't have an attorney and you're handling this pro se, it might be a good chance for you to retain someone who can assist you with what happens after your parole is granted. Now, if you have something that's pretty much straightforward, where your parole was approved, but you don't have removal proceedings pending, but you are eligible for adjustment because you meet the criteria for that, great. That might be an option to go ahead and file an adjustment of status, but you want to make sure you have everything in front of you where you're sure before you send out those applications. Now, of course, like I've said in my previous videos, I'm going to say it again. We don't know if we're going to face some legal challenges. Right now, everything is fairly new. For all of you who have filed your applications, great. Now it's just sitting back and waiting for your receipt notices, your biometrics appointments, and seeing how the process goes about for an adjudication on the parole in place. But for those of you who haven't filed yet, and you're still in that phase of, should I file? Should I not? Right? Because what are the risks? You've been under the radar and you haven't really filed anything in the past. Do you really want to put your information out there? There's several things that goes in a person's head. So just want to mention that if you have a situation where you are in removal proceedings, they're administratively closed, or you are in removal proceedings and you have like an individual or something coming up, those removal proceedings don't just go away. You have to take care of it, and this all can be done after the parole in place is approved, and you can go from there. So I hope today's video was helpful. I just wanted to go over certain things that I thought were important to discuss, that I reviewed when I was working on cases. And of course, I was dealing with cases with a very heavy immigration history, heavy, complicated, and you really have to decide whether it's best for you to file for parole in place and whether you're eligible. So thank you so much for watching. If you have not hit the subscribe button yet, this is your chance to do it. Hit the bell notification to stay updated on anything I post on U.S. immigration. Hit that like button, share with your friends and family, and I will see you soon.